The Objective News Network, Judge Engoron, and the Trump fraud case in New York. Before I begin today's story, I need to say that I am not a licensed attorney. However, I am an investigator that has more than just a passing knowledge of the law, especially criminal law. I've also taken on some very, very tough cases, operating as pro se, or in other words, on my own, without the help of an attorney, as I have worked for attorneys and advised clients in my nonprofit Institute for Complexity Management, or ICM. We encourage you to visit ICM to see examples of the investigations and the court cases we have helped both attorneys and the courts deal with. So please consider the following as an advised opinion piece based on interpretation of the law and the logical analysis of what we call genuine issues of fact in the matter of the so-called Trump fraud trial. The due process provisions of the United States Constitution absolutely guarantee certain fundamental rights to all defendants, irrespective of the state in which civil or criminal matters are tried. These rights supersede the laws of the individual states. In the matter of former President Trump's fraud trial in New York Executive Law 63, paragraph 12, doesn't require that a legal finding of fraud by the New York courts be based on the traditional elements of what constitutes fraud in every other state of the United States. Rather, for purposes of New York Law 63, paragraph 12, the term is loosely defined as, quote, the word fraud or fraudulent used herein shall include any device, scheme, or artifice to defraud, and any deception, misrepresentation, concealment, suppression, false pretense, false promise, or unconscionable contractual provisions, close quote. The New York law does not specify the specific elements of the crime of fraud that must be proven beyond all reasonable doubt to prove guilt in a court of law. Instead, New York Executive Law 63, paragraph 12, leaves prosecutors and judges remarkable and improper latitude to determine guilt or innocence in the absence of evidence proving beyond all reasonable doubt the same criminal elements of fraud that are required in every other court of law in the United States. In New York, we have a highly politicized Democrat prosecutor, Ms. Hnatio James, that has openly and publicly stated that she was out to get former President Donald Trump operating in league with a self-admitted Democrat judge, Judge Engoron. Why, given these obvious and very real conflicts of interest, did these two officers of the courts not recuse themselves in the interest of both fairness and justice? In any event, this is exactly how Judge Engoron was allowed to express nothing but his opinion in the absence of any transparent vetting of evidence proving that former President Donald Trump and members of his family were in fact guilty of the elements of fraud, and in this case, criminal fraud. That means that New York Executive Law 6312, Ms. Hnatio James, the prosecutor, and Judge Engoron himself were able to change the meaning of fraud to suit their own political ends and summarily declare the president guilty of committing fraud. In every other state of the Union except New York, fraud must be proven in a court of law based on the following 9 things. First, it must be proven that you have made a representation of fact. In the Trump matter, the valuations of assets were never represented as genuine issues of fact, but rather merely opinion, because the determination of value of assets is a negotiated process, not an individual decision. In the Trump case, banks, lenders, underwriters, other insurers, and government regulators all had to agree that the valuations provided by Trump's accountants were reasonable before any monies could be legally lent to any Trump organization. Second, it has to be proven that the representation of so-called fact, the valuations, were false. Again, in the Trump case, there was no representation of fact in the first place. Rather, any valuations were actually the collective agreement or opinion among multiple parties that the valuations provided by Trump accountants were reasonable. Third, there is the issue of materiality. In the Trump matter, this means that any misrepresentation of fact, the valuations, must have some type of bearing or relationship on the outcome of the fraud, measured in terms of some type of damages to someone. In other words, the misrepresentation of fact has to be materially related to some type of damage. In the Trump matter, there was no misrepresentation of fact in the first place, and no evidence of any damage. No one lost any money. In fact, all parties to the arrangement benefited. Fourth, you must prove that the defendant in this case, former President Trump, actually knew that he was making a misrepresentation of the truth. But since the valuations were not representations of fact, but rather merely a collective opinion by a number of fiduciarily responsible parties, the determination of value of assets was a negotiated process, not an individual decision made by the defendant in this case, former President Donald Trump. Fifth, you must prove that the defendant had direct knowledge that President Trump himself, as an individual, knew he was attempting to deceive by directing his accountants to come up with false numbers. Again, since the valuations were not representations of fact in the first place, but rather merely a collective opinion by a number of fiduciarily responsible parties, the determination of values of assets was a negotiated process, not an individual decision by the defendant himself. That's why the numbers are required to be caveated on the form itself as subject to due diligence by lenders. 6. There is no injured party in the Trump matter. In the Trump matter, there was no misrepresentation of fact in the first place, and certainly no evidence of any damage. No one lost any money. In fact, all parties to the arrangements benefited from them. 7. The injured party, of which there was none in the matter of President Trump, had to rely on the veracity or truth of the intended misrepresentation of fact. Yet again, no misrepresentation of fact, since the valuations were really a collective opinion by a number of individual fiduciarily responsible parties. The determination of value of assets was a negotiated process, not an individual decision by the defendant himself. in this case, President Trump. 8. You must prove that the injured party, of which there was none in the Trump matter, had a right to rely on the matter of fact as relayed to them by the defendant. But in the Trump matter, there was no misrepresentation of fact in the first place, and there was no injured party. No one lost any money. In fact, all of the parties to the arrangement benefited from it. 9. You must prove that the injured party, of which there was none in the Trump matter, actually suffered some type of real, tangible damage. Yet again, in the Trump matter, there was no misrepresentation of fact in the first place, and there was no injured party. No one lost any money. In fact, all parties to the arrangement benefited from it. Under New York Executive Law 63, paragraph 12, you do not have to meet the same 9 stringent conditions that I just highlighted that you do everywhere else. Let's make a quick assessment in the matter of Judge Engoron and President Trump. It is what it is. Thank you for watching. Please tell your family, friends, colleagues, and followers about us. Please subscribe and please share your comments with us. This is a very important story about the nature of the justice system in the United States. Is it working or isn't it?